did anyone in the Prime Minister's office at any time communicate with anyone in the former Attorney General's office on the matter of the criminal prosecution of SNC Lavalin, yes or no?
As the Prime Minister has said earlier today, these allegations are false.
She spoke truth to power behind closed doors, and the Prime Minister fired her. Will she now speak truth to power in front of all Canadians?
Neither my predecessor nor myself has received directives with respect to the dealing of this particular case.
Did the Prime Minister fire the Attorney General because she refused to do his dirty work, yes or no?
No such direction was given to my predecessor. No such direction has been given to me.
The Trudeau government is being berated thanks to allegations in a report by the Globe and Mail. Here's a quick summary of those allegations involving the Prime Minister's office, former Justice Minister Jody Wilson-Raybould, and the engineering firm SNC Lavalin. The Montreal firm is Canada's largest engineering and construction company, and it faces what's been described as the greatest case of corruption fraud in Canadian history. It's alleged that between 2001 and 2011, SNC bribed public officials in Libya with millions of dollars in order to secure government contracts there. The RCMP laid charges in 2015. Today, SNC argues those responsible are no longer working for the company, and it has beefed up its ethics and compliance rules. That's why SNC has been pushing for a DPA, a deferred prosecution agreement, instead. This option became available back in September. It's kind of like a plea bargain. Charges are dropped if the accused, say, admits to wrongdoing or pays a big fine or cooperates with authorities. But the Globe and Mail reports that in October, Canada's Director of Public Prosecutions shut the door on SNC's request for a DPA. That's when officials from Justin Trudeau's office allegedly turned to Jody Wilson-Raybould, then Justice Minister, who reportedly refused to pressure the prosecution office to change its mind. Last month, Wilson-Raybould was shuffled out of her position as Justice Minister. To walk us through how the day and the fallout unfolded, the CBC's David Cochran is here. Hey, David, thanks for being with us.
Quite a day.
Yes, quite a day. The Prime Minister is denying the claims, sort of, but what did he say specifically?
Yeah, he gave a very careful answer that initially it seems like a very explicit denial, but at the time it also looked like a narrow one because it was so carefully crafted. It didn't deal directly with the allegations reported in the Globe and Mail by Bob Fife, Stephen Chase, and Sean Fine that Jody Wilson-Raybould was pressured. He talked about being directed. They talked about her being pressured. So that didn't go unnoticed by reporters here or at the Prime Minister's event this morning where he's taking questions. Just take a look at this exchange.
At no time did I or my office direct the current or previous Attorney General to make any particular decision in this matter.
But not necessarily direct, Prime Minister. Was there any sort of influence whatsoever?
Yeah. As I've said, at no time did we direct the Attorney General, current or previous, to take any decision whatsoever in this matter.
And you can hear it there again, the use of the verb direct or directed. He gave that answer 3 or 4 times in both English and in French, never dealt directly with influence or pressure, spoke about directing, did not deal with questions about pressure or influence at all when he spoke with reporters today.
So how did that evolve throughout the day? Because this was obviously the big story and played out very much so in question period.
Yeah, it got rolling fast. And that sort of parsing, that careful parsing of the answer directed, Andrew Scheer, the opposition leader, he picked up on that immediately. And he made the point when he spoke with reporters that this sounded like something a lawyer had written rather than the actual words of the Prime Minister. Here's Andrew Scheer.
Prime Minister must immediately come clean to Canadians about what he knew about this case and when he knew it. Nothing short of full disclosure is acceptable. His carefully crafted and legally vetted answers today fall far short in this regard.
And he may be onto something there when he says legally vetted, because I spoke with PMO officials this afternoon. We've been speaking to them all day, trying to get to the bottom of this. And they made the point that the Prime Minister was so careful because of the legal issues connected with this case. But they insist on background. They say to you there were no pressure, no influence, no nothing, no attempt to direct Jody Wilson-Raybould to do anything about this. And as things went along, that answer expanded, and that actually became part of the answer when question period happened and Justice Minister David Lametti started taking questions. Here's how that went down.
Mr. Speaker, as the Prime Minister said earlier today, neither the Prime Minister nor his office put my predecessor or myself under pressure, nor gave any directives. These allegations contained in the Globe and Mail, Mr. Speaker, are false.
So welcome to Cabinet, David Lametti, right? You know, the opposition is also drawing a straight line between what happened with SNC Lavalin, as reported in the Globe and Mail, to Jody Wilson-Raybould's departure from the Justice portfolio and Lametti's ascendance there. Again, the Prime Minister's office is denying this. They have swear up and down that if Scott Bryson had not quit, there wouldn't have been a shuffle, and Jody Wilson-Raybould to this day would still be Justice Minister and Attorney General.
So the interesting part, and probably part of the reason those questions are being raised, is because when Jody Wilson-Raybould was shifted out of that position, out of Justice into Veterans Affairs, she posted, essentially I think it was a blog, that made some very interesting claims about, you know, possibilities of political, or insinuations about political interference, but never said about what. What is she saying today?
Yeah, she is saying absolutely nothing today, and that's a real problem for the Prime Minister's office on this, because if there is one person who could put a nail in this story and put the whole thing to bed, is Jody Wilson-Raybould. She has said nothing beyond no comment. Just take a look at what happened when our colleague Chris Rands tracked her down before question period.
Hi, Minister. What's your reaction to the Globe and Mail story today, please?
I don't have any comment.
And were you pressured by PMO, ma'am? Anyone at PMO?
So there you go. I followed up with her office today. I asked if she would endorse the Prime Minister's statement that neither he nor his office directed her on this. And again, I got a no comment. So actually, we have this rare thing of a cabinet minister who won't back up her boss in public, seems to be going to great lengths to avoid backing up the Prime Minister's statements on this. And if you want a story to go away, this is not how to do it. So like Fife, Chase, and Fine, they broke a big story today. Her refusal to say anything is going to ensure that there's going to be a big story going into tomorrow and the days ahead.
That silence speaks volumes.
It does indeed.
Thanks, David. The CBC's David Cochran. So what else is the government willing to say about the allegations, and what kind of answers will the opposition be demanding? Marco Mendicino is Parliamentary Secretary to the Minister of Infrastructure. Chris Warkentin is Conservative Deputy House Leader, and Nathan Cullen is the NDP Democratic Reform Critic. All three join me from the foyer in the West Block. Nice to see you all. Thanks for being with us. Really appreciate it. Mr. Mendicino, I'm gonna start with you. Today, in response to the allegations leveled by the report in the Globe and Mail, the Prime Minister said neither the current nor the previous Attorney General was ever directed by me or by anyone in my office to take a decision in this matter. He used the word directed. I'm asking you, did anyone in the Prime Minister's office pressure the former Attorney General, Jody Wilson-Raybould, to intervene in the case?
Neither directed, nor pressured, nor influenced. Insert whatever adjective you want. The Attorney General is an office that the Prime Minister respects, along with the independence of the judiciary, as well as the prosecution service. You heard David Lametti, the Attorney General and the Minister of Justice, say the same thing today, repeatedly in question period.
Why didn't the Prime Minister use the word pressure? Why did he say direct?
I'm confident that's entirely his view, and his position has been clear on it. He respects the office of the Attorney General. He respects the independence of the judiciary. This is a position that we've taken not only in answer to these spurious allegations today, which are inviting conjecture, none of which is helpful, but this is a theme that has run through our government. We respect the judiciary, we respect the independence of the justice system, and I believe that our work speaks to that.
If the allegations are false, Mr. Mendicino, why won't Jody Wilson-Raybould, a minister in the Prime Minister's cabinet right now, say as much?
Minister Wilson-Raybould had an incredible tenure as the Minister of Justice. She spoke about that. She issued a statement following her new portfolio. I would add that her new portfolio is one in which she has thrown herself into. She's an exceptional, exemplary member of this team, and I know that the work that she's doing on behalf of our veterans means a lot to them and to all of Canada.
That doesn't answer the question, though. Why isn't she saying the allegations are false?
Minister Wilson-Raybould has issued a statement, and she obviously respects the privilege.
No,
she has issued a statement both following her new portfolio as well as in answer to these allegations, which again are not based in any fact. They invite conjecture, they invite speculation. She's a member of the team, and she does incredible work on behalf of our veterans, and she's serving with great distinction.
Mr. Warkentin, your colleague Peter Kent said he'd like to see some kind of inquiry into the conduct of the Prime Minister's office outlined in the Globe story. Is that the official position of the Conservative Party, and what would that inquiry look like?
We're going to use every mechanism to get to the bottom of this. There's clearly a cover-up. We have asked repeatedly in the House of Questions, very simple questions, yes or no questions. We get stonewalled again and again and again. Of course, the Prime Minister had a very carefully crafted answer today. He repeated the same line over and over and over again, as if he had consulted with a lawyer as to what he should say and what he should not say. He repeated the same line over and over again. It's clearly that they're covering something up. An inquiry, some type of inquiry needs to take place. We will use every mechanism to get to the bottom.
Is it clear? Is it really so clear, though, Mr. Workington? Mr. Mendocino just went further than the Prime Minister. He did say that no pressure was applied, no direction was given. Why is that not enough?
Because the Prime Minister never said that. And as a matter of fact, what we do now have is a respected journalist in a respected newspaper writing that there's sources that are saying otherwise. So let's get to the bottom of this. Let's have even the former Attorney General, who was fired from her job, a respected parliamentarian, a respected leader from the province of British Columbia, she should be able to speak as well. Of course, we have seen that the government wouldn't let her speak in question period today. First, they turfed her. First, they fired her, and now they're silencing her.
Sorry, I just want to follow up because you said if you concluded that the Prime Minister had not said that he didn't pressure, which was, of course, my question to Mr. Mendocino. Exactly. If you do hear from the Prime Minister him using the word pressure, is that enough to satisfy?
Well, I've heard things from the Prime Minister that later turned out not to be true. So, I think that this is we need to have some kind of an inquiry. We have to get to the bottom of this. And the Prime Minister was very careful with the language that he used today. But him changing his story in the coming days probably won't change my mind that something has to be done to uncover what has gone on here.
Mr. Cullen, does your party want to see an inquiry?
Oh, we need to see a lot more than what we're hearing so far from the Liberals. As you said, Vashi, when the Prime Minister was asked directly, outside of the carefully scripted language that he had, he would refuse to answer. Because let's understand what the story is. The allegations that have been put forward are that the Attorney General was pressured not to go through with a case against SNC Lavalin, who had been found both in other countries, but also in Canada, of fraud and corruption. And that if you look at that letter that Marco referred to by Jody Wilson-Raybould when she was fired from being Attorney General, she said, "It's a pillar of our democracy that our system of justice be free from even the perception of political interference and uphold the highest levels of public confidence." I've never seen anything like this from a cabinet minister when they're moved from one portfolio to another. The Prime Minister's office then let it be known that she was difficult to work with and there were some other problems, which I think is ad hominem and misogynistic, frankly. That we have the allegations of a company, SNC Lavalin in this case, which illegally gave more than $100,000 to the Liberal Party of Canada, proven in court, who is now facing fraud charges. And lastly, Vashi, if you look at the Liberals' last omnibus bill, the very last section of that bill, which even Liberals on Finance Committee said wasn't right to be in there, allows for a company convicted of fraud to take an alternative course away from that conviction and still apply for government contracts. It's called the SNC Lavalin clause. All of this conspires itself to believe that if the Attorney General was suddenly dismissed from her duties and had resisted pressures from the Prime Minister's office, whether it came directly out of Trudeau's mouth, I think is irrelevant. I think if it comes out of the Prime Minister's office, this is the very definition of scandal and corruption that the Liberals, as much as anybody else, should be interested in getting to the bottom of, rather than just these carefully scripted legalistic answers that we get from the current Attorney General.
I want to pick up on one of the last points you made and get Mr. Mendocino to respond, give him a chance to respond. On the issue of deferred prosecution agreements, Mr. Mendocino, are you sympathetic? Do you understand the optics here, that your government introduced this option, fast-tracked it through Parliament, and according to the Globe's report, the PMO then, and although you deny it, pressured the Attorney General of Canada to use it? Do you see how the perception, as alluded to in the letter from Minister Raybould, is not a good one?
There has been nothing but sunlight on the issue of remediation agreements and deferred prosecution agreements, as they're also referred to. This has been the subject of ongoing public debate, not only in the House of Commons, but also before the Senate. Wow. You want to talk about conversations, you should see the number of MPs from the opposition that SNC Lavalin have spoken to, including Andrew Scheer. Would have been great to be in a fly on the wall in that meeting. The point of the matter is...
But you're a government. You're a government. You're the ones capable of introducing the legislation, putting in the clause, pushing it through,
put it in.
Right?
The point of the matter is this. This is a tool which has been long supported and advanced by experts when it comes to those who understand how to keep Canada competitive, as well as how to ensure that prosecutors have the tools that they need so that scarce judicial resources are not wasted. I can speak to this as a former federal prosecutor, and I can tell you that this is absolutely the kind of tool that has been out in the public domain for quite some time, and certainly before we arrived here on the Hill. And as for the rest, Nathan used the word conspiracy. That's all this is. This is nothing nothing but conjecture, and it's not helpful. And as for the members of the committee...
I'll get you both to respond, don't worry.
And as for the members of the committee who debated this bill, again, under the sunlight of open and transparent proceedings, the matter was put forward and supported, and now it's in the Senate.
Okay, Mr. Cullen, I'll grab you first because you look like you're going to...
I'm sorry, actually, I should clarify that. Now it's enforced. I beg your pardon.
It's enforced now, yeah.
So SNC Lavalin, in court, admitted to illegally donating more than $100,000 to the Liberals over the last 10 years. SNC Lavalin has been convicted of fraud in the Libya case, but also now with this Montreal hospital. SNC Lavalin asked for this white-collar crime deferment, that if they get convicted of fraud in Canada, which would normally exclude them from ever applying for those lucrative government contracts ever again, suddenly in the back of a 550-page omnibus bill, the Liberals included. Liberal members on the Finance Committee said it was inappropriate for this section to be in here and suggested moving it over to Justice so we could understand what it means. The Liberal Party, the Liberal government said no. This is the very definition.
They didn't get the DPA, right? Didn't the system work as it should, though, despite what...
But the allegation here is that the Liberals set up the pathway for this company, which had illegally donated to them for over many years, illegal donations to them over many years, was caught up in another corruption scandal, which would have forbid them from doing this, and they leaned on their Attorney General. When she wouldn't do it, they fired her, because we're still looking for the reason why Jody Wilson-Raybould is not the Justice Minister of Canada. The first Indigenous woman to ever hold a portfolio. The Prime Minister said how wonderful this is. Suddenly he fires her with no explanation, moves her over to Veterans Affairs, and Jody puts out a letter that says we must be able to speak truth to power, and that the question of influence on her was at the heart.
To be fair, we don't know because she won't answer the question.
But Vashi, we asked her in Parliament today, and the Liberal new Justice Minister kept getting up in her place and answering for her, rather than letting Jody Wilson-Raybould speak as we were asking her to do, because she's the only one that can answer that question,
I take it,
not the current
but
Justice Minister.
She could also, Mr. Workin, she could also speak to the media, and she isn't saying that.
What she did say when she left her portfolio, when she was fired, was that she had spoken truth to power. Now, the allegations...
She didn't say in which instance.
Well, I can tell you that when the Globe and Mail is reporting that there's a source that's saying that it is in this instance that the Prime Minister's office was pressuring her to roll over and do what the Prime Minister was demanding, that is a violation of the democracy and the judiciary that we as a nation trust and put our trust in. The bombshell today needs to be answered for. The allegations are very, very clear that she was being pressured by the Prime Minister's office to do something. She refused to do it, and she was fired for doing that. That is what needs to be investigated. It needs to be known. Canadians deserve to know what went on. When she spoke about speaking truth to power, when she talked about her job and the role that she played, that she spoke to truth to power. Now with these allegations coming forward, the picture is becoming very, very clear, and Canadians deserve answers.
Mr. Mendocino, final question to you. If your government and the Prime Minister's office has nothing to hide, are you open to an inquiry?
To be fair, what Justice Wilson-Raybould said when she received her new assignment in Veterans Affairs is that she was proud of the work that she did during her tenure as Justice Minister, and that she was honored to go on to help our veterans.
She did also highlight, though, that
she spoke with great integrity at that moment.
Interference.
She did speak to political interference.
She spoke with great integrity on receiving her new assignment and the work that she did during her tenure.
You asked her,
wait a second, sorry, Mr. Mendocino, you didn't answer the question, though, that I had asked, which is that if your government has nothing to hide, if the Prime Minister's office has nothing to hide, are you willing to open yourselves up to an inquiry?
Let the opposition do what they will. This is a government that is focused on
the majority government. Will you let it happen?
Canadians, and I will tell you that this is good work that's being done. We have the Prime Minister out on the road. We have a Minister of Veterans Affairs who's helping veterans, and we have a new Attorney General who is doing everything that he absolutely can to improve access to justice for all.
Well, I think that's a no, Vashi.
Okay,
asked a direct question over and over again.
We will leave it there. I'm unfortunately out of time. Thank you very much to all three of you. Really appreciate your time.
Thanks, Vashi.
The opposition is demanding answers. So legally, what is at play here? Patricia Adams is executive director of Probe International, an independent think tank and watchdog over the environmental consequences of Canadian government and corporate activities around the world. Ms. Adams joins me now from Toronto. Hi there. Thanks very much for being with us. Really appreciate it.
Pleasure.
So the center of the controversy today is really what we just described, this provision in the criminal code called a remediation agreement, otherwise known as a deferred prosecution agreement. Until today, I really have to be honest, I did not know a lot about it. Can you tell us a bit about this provision, and why it could be used?
Yes, it goes back to the 1930s, actually, when in the U.S. they used it to deter future crimes by juvenile delinquents. They said if the child commits a crime and agrees to rehabilitation, that they will not prosecute, so that the minor does not end up with a corporate record. So in 2004, the U.S. Department of Justice and the Securities and Exchange Commission began to consider using them and started using them to deal with criminal charges against corporations. And it was after that that they took off. And they have been used now for as many years, since 2004, in the United States. Hundreds of DPAs have been negotiated. There is growing opposition to them in the United States. Essentially what happens is the prosecutor, in this case the SEC or the Department of Justice in the US, or the prosecutor in Canada, would agree or invite actually a corporation that has been accused of a corporate crime to negotiate a deferment of prosecution. The corporation has to agree to it, they have to pay a fine, they have to agree to have a monitor who is implanted really into the corporation to monitor their activities. And sometimes these fines are huge. In the case of the U.S., some of them have approached close to $2 billion. There are a lot of problems with DPAs. Probably the most profound one is that they undermine the administration of justice. So there's growing opposition to them in the United States.
What qualifies, like how can a corporation qualify to agree to one, or what would prompt the prosecution to suggest it? Is there like a line in the sand, a type of charge, or a point at which you can't go over it and you won't be offered it, that kind of thing?
Not that I'm aware of. And in some cases in the United States, there's a fear that the prosecutors, who are very zealous, are actually conjuring up accusations against firms. Because one of the interesting side effects of this in the U.S. is that it has become a big money earner for the Department of Justice and the SEC. A figure that I looked at recently, which is now about a year or two out of date, I mean, it's about a year or two old, indicated that there were $50 billion that had been collected by the Department of Justice and the SEC against these corporations. So it gives the prosecutors an incentive to go after firms, even if there is no corporate crime. And then on the other side, the corporation that is faced with this is worried, of course, about a criminal trial and about the bad press that comes from that. So they often buckle and agree to it, even if the charges cannot stand up in court. They will go along with it. So all of the incentives are wrong. It's done behind closed doors. You don't have the salutary effect for the public of seeing the charges against a corporation being aired in court, being challenged, cross-examined, and so on. It's all done basically secretly. So it undermines the rule of law.
Yeah, I was going to ask. So is the incentive just money then? Because I'm thinking, as Canadians listening to this, if a corporation is guilty of white-collar crime, and in some cases, extreme, especially as you describe, extreme cases of it, you want to see them punished. I think there's a frustration among Canadians who hear about this over and over again. So is the incentive for prosecutors literally just money?
No, they also get the opportunity to say, we are turning these corporations around. We are installing monitors in them. We're changing corporate culture. But money is not the only incentive. The other thing to keep in mind is that the corporation itself is not a being. It has no criminal mind. It is a corporation. It's the individuals in the corporation who commit the crime, and those are the people that should be prosecuted. Those are the ones that prosecutors should go after. Of course, if a corporation has benefited from the illicit acts of its staff members, then it should be disgorged of any of the benefits that they got from that. But the only way to deter future corporate crimes is to take away the liberty and the assets of the individuals in these corporations who have actually committed the crime. Otherwise, these individuals get away scot-free. And the other thing that it does is it turns the cost of a charge against a corporation into merely a cost of doing business. And so corporations in future will say, well, we don't have to worry because we're not going to go to jail and we're not going to lose our assets. We're just going to have to pay a fine. So it turns turns it into a cost of doing business, and that is to the detriment of the rule of law in this country.
In this case, and it is all allegations, but what would, well, we actually, the part about the SNC Lavalin hoping to get a DPA is not an allegation. We know that for a fact. What would they have to gain by getting one or lose by not getting one?
Well, they lose because if they gain if they get a DPA, because then they would not have to go to trial, they wouldn't be charged, they wouldn't be convicted, and they would not then, and if they were indeed found guilty, they would not suffer the integrity regime standards, which says that they could not get Canadian government contracts for 10 years. And that would be a major cost to SNC Lavalin because they depend on government contracts. But it would be bad for Canada. DPAs ultimately undermine confidence in the judicial system. And for that reason, I think they should not be given one. And I think that if indeed the minister was pressured by the Prime Minister's office to secure one for SNC Lavalin, it was wrong to be pressured. It was good that she didn't buckle. She did the right thing. And that I think SNC Lavalin should have its day in court and prove its innocence if it can, and if it can't, then it has to suffer the consequences.
The public prosecution has decided not to go ahead with the DPA in this case, and that is a decision that SNC is appealing. Do the allegations that are made today, could that have any impact on that appeal process, do you think? Could it color it?
Oh, definitely. I think, especially at this particular time in Canadian history, when we need our government to demonstrate that our judicial process is not politicized, it has to stick with the principles that were set out by the Department of Justice and the decision of the Department of Justice and also the public prosecutor, that it would not give a DPA to SNC Lavalin.
Okay, I have to leave it there, but thank you very much for your time, Ms. Adams. Really appreciate it.